Welcome to Section 4.1. This is the 28th session of the CISSP Exam Prep series. In this session, we'll map the legal system that sits under every security decision. We'll answer several questions. Why should a security professional care about categories of law? What is criminal law and what does it punish? What is civil law and how is it enforced? What is administrative law and where does it come from? And what keeps all of these in check? Why does this matter beyond the exam? Because the moment an incident turns serious, the legal category decides everything that follows. Picture a payment processor that discovers an insider stealing customer records. Is this a criminal case the government prosecutes? A civil dispute the company files itself? Or a regulator's enforcement action? Knowing which lane you are in tells you who acts, what evidence you need, and what penalties are on the table. Why should you care about categories of law at all? Because security work does not happen in a vacuum. Governments at every level pass overlapping rules that touch your systems. As a professional, you have to reconcile the demands of several jurisdictions at once. For a company that operates in many countries, that web gets even denser. So you do not need to be an attorney, but you do need to recognize which type of law you are dealing with and when to call someone who is. What is criminal law? It is the body of rules that keeps society safe and orderly. Criminal law forbids serious acts against people and property, and the police enforce it. When these laws are broken, the government itself brings the case against the accused. Penalties are the heaviest of any category. They range from community service and fines all the way to prison. Think of it as the referee who can eject a player and ban them from the league. The state, not the injured person, throws the flag. What is civil law? It is the framework that lets an orderly society and its businesses function. Civil law handles disputes that are not crimes, but still need a neutral judge, like contract fights, employment matters, and property deals. Here, the government does not take sides. The person who feels wronged must hire counsel and file the suit themselves. There is no prison at the end of a civil loss, but the price can still be brutal, with damage awards reaching into the millions. Picture two companies arguing over a broken contract. The court simply provides the room, the judge, and the jury. What is administrative law? It is the detailed rulemaking that government agencies create to run their day-to-day operations. Lawmakers cannot spell out every procedure for every situation, so they grant agencies room to fill in the gaps. Agencies do this through regulations, policies, and orders. These carry the force of law without a fresh vote from the legislature. Think of a building code inspector. The legislature said buildings must be safe, and the agency wrote the hundreds of specific rules that define what safe means. What keeps all of these laws in check? A single supreme authority sits above them all, the Constitution. Every criminal, civil, and administrative rule must obey it. Courts review laws for constitutional problems, with appeals rising all the way to the highest court. If a law violates that supreme authority, a court can strike it down and make it void. And administrative rules face an extra limit. They can never contradict the criminal and civil laws already on the books. So the whole system stacks neatly with the Constitution on top. So let's bring it together. 3 categories of law shape your world as a security professional. Criminal law punishes serious wrongs and the government prosecutes. Civil law settles disputes and the wronged party files the suit. Administrative law is the fine-grained rule-making agencies use to operate. All 3 answer to the Constitution and to judicial review. Learn to spot which category an issue falls into, and you will know who acts, how, and when to bring in legal help. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to Section 4.2, Part 1. This is the 29th session of the CISSP Exam Prep series. This part opens our tour of the specific laws that shape information security work. In this session, we'll focus on the laws that target computer crime and protect federal systems. We'll answer several questions. Why did lawmakers write computer-specific statutes at all? What does the Computer Fraud and Abuse Act cover? How did the Infrastructure Protection Act widen that reach? What does the Federal Information Security Management Act require? And what did the wave of modern cybersecurity laws add? Why does this matter beyond the exam? Because these statutes define what counts as a crime in your environment and who you can call when one occurs. Picture a contractor who quietly copies a defense agency's files onto a personal drive. The question of whether that is a prosecutable federal offense turns entirely on laws like these. When you understand the rules, you know which incidents demand law enforcement and which documentation will hold up. Why did lawmakers write computer-specific statutes at all? Because the old rules did not fit the new crimes. Early prosecutors tried to squeeze computer offences into traditional criminal law, and many cases collapsed. Judges felt that stretching an old statute to cover a modem was a reach too far. So legislators responded by defining computer crime directly and attaching clear penalties. Think of it like writing traffic laws once cars appeared. You cannot police a highway with rules meant for horses. What does the Computer Fraud and Abuse Act cover? It is the cornerstone statute for federal computer crime. It was written narrowly, on purpose, to cover only crimes that cross state lines, keeping it on solid constitutional ground. It protects computers used by the government, by financial institutions, and any machine whose compromise disrupts those operations. Over time, it grew to cover any computer involved in interstate commerce and to criminalize malicious code. Picture a national fence around critical machines. Cross it without authorization, and this is the law that catches you. How did the National Infrastructure Protection Act widen that reach? It stretched the fence beyond computers themselves. Lawmakers realized that attackers could cripple systems that were not just data centers. So the Act extended protection to railroads, pipelines, power grids, and telecommunications lines. It also reached beyond domestic borders to cover systems used in international commerce. And it treated any reckless act that damages critical infrastructure as a felony. Think of guarding not just the bank vault, but the roads and power lines that keep the bank running. What does the Federal Information Security Management Act require? It forces every federal agency to run a real information security program. That program has to cover the agency's own operations and the work of its contractors. It also lays out the ingredients of an effective program through official implementation guidelines. Those ingredients include regular risk assessments, policies grounded in that risk, security awareness training, periodic testing of controls, incident response procedures, and continuity planning. Picture a mandatory health checkup for a whole agency, repeated on a schedule, with the results documented. What did the wave of modern cybersecurity laws add? It modernized and divided the responsibilities. One law updated the earlier Management Act and centralized most federal cybersecurity duties under the Homeland Security Department, while defense and intelligence kept their own lanes. A second law tasked the Standards Agency with coordinating voluntary cybersecurity standards nationwide. A third created a national center to share threats and warnings between government and private organizations. And the Standards Agency publishes a widely used series of security guidance, from a controls catalog to a voluntary risk-based framework that many private firms adopt. Think of it as building a shared early warning network plus a common playbook everyone can borrow. So let's bring it together. Lawmakers wrote computer-specific statutes because old law could not stretch to fit new crime. The Computer Fraud and Abuse Act became the cornerstone, guarding government and financial systems across state lines. The Infrastructure Protection Act widened that shield to pipelines, grids, and international commerce. The Federal Management Act made security programs mandatory for agencies and contractors. And the modern wave centralized duties, coordinated voluntary standards, and built a shared warning center. Together, they form the federal backbone you will keep meeting on the job. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to Section 4.2, Part 2. This is the 30th session of the CISSP Exam Prep series. This part turns from computer crime toward the laws that protect ideas and creative work. In this session, We'll cover the 4 pillars of intellectual property and how software fits among them. We'll answer several questions. What is intellectual property and why does it matter? How does copyright protect creative work? What do trademarks protect? What do patents protect? What are trade secrets? And how do modern software licenses actually work? Why does this matter beyond the exam? Because in a service economy, ideas are often the most valuable thing a company owns. Picture a startup whose entire worth is its recommendation algorithm and its brand name. If you cannot tell a copyright from a trade secret, you cannot advise on how to protect either one. Choosing the right form of protection is a security decision, not just a legal one. What is intellectual property and why does it matter? It is the collection of intangible assets a company creates with its mind rather than its machines. A recognizable brand, a secret recipe, a clever invention, a body of writing. These are all intellectual property. As economies shift from making goods to providing services, these assets often outweigh the physical ones. A whole family of laws exist to protect the owner's rights. Think of it as fencing off the products of imagination so that others cannot simply harvest what you created. How does copyright protect creative work? It guards original works of authorship against unauthorized copying. Copyright covers categories like writing, music, art, film, and sound recordings. For software, it protects the actual source code as a literary work, but not the underlying idea or process. Protection is automatic the moment you create the work, though formal registration strengthens your hand in court. And there is a modern twist. A dedicated digital act bans tampering with copy protection controls and shields service providers from liability for what their users transmit. Picture a signature baked into a song. Anyone can hear it, but no one may legally clone it. What do trademarks protect? They protect the words, slogans, and logos that identify a company and its offerings. The goal is to prevent confusion in the marketplace, so customers know whose product they are buying. Like copyright, basic protection is automatic once you use the mark in public. Formal registration adds official recognition and lets you use the registered symbol. To qualify, a mark must not be confusingly similar to an existing one, and it must not merely describe the product. Think of the swoosh on a shoe. It says nothing about rubber or laces, yet everyone knows the source. What do patents protect? They protect inventions, giving the inventor exclusive rights for a set period before the invention enters the public domain. A utility patent, the main type, lasts 20 years from the application and covers how something works. To qualify, an invention must be new, useful, and not obvious. There are also design patents, which cover only the appearance of a product and last 15 years, and plant patents for new plant species. Picture a temporary monopoly. In exchange for publishing exactly how your invention works, you get years of exclusive use. Then everyone may build on it. What are trade secrets? They are the crown jewel information a company protects by keeping it hidden, not by publishing it. A formula, a manufacturing process, an internal model, all lose their value if exposed to competitors. Unlike copyrights and patents, you never register a trade secret because registration would force public disclosure and end the secrecy. Instead, you protect it with strict access controls and non-disclosure agreements. Federal law adds teeth, making the theft of trade secrets a serious crime and allowing civil suits as well. This is why source code is often guarded as a secret rather than merely copyrighted. Think of a locked recipe vault that only a handful of people may ever open. How do modern software licenses actually work? They set the terms under which you may use software, and they come in many flavors. A perpetual license is a one-time purchase for indefinite use, while a subscription license charges a recurring fee. Open source licenses grant freedom to use and modify under conditions, and freeware is simply free to use. Enterprise agreements cover a whole large organization, and end-user agreements spell out individual rights during install. Concurrent use licenses cap how many people use the software at once. Named user licenses tie access to specific people, and cloud service agreements govern software delivered over the internet. Think of it as a menu of rental contracts, each drawing the line between what you may and may not do. So let's bring it together. Intellectual property is the intangible value a company creates with its mind. Copyright guards creative expression and source code, with the Digital Act protecting the controls around it. Trademarks protect brand identity, and patents protect inventions for a limited term in exchange for disclosure. Trade secrets protect value through secrecy, backed by strong controls and federal law. And software licenses set the rules of use across a wide menu of models. Match the asset to the right shield, and you protect what a modern business is truly worth. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to Section 4.2, Part 3. This is the 31st session of the CISSP Exam Prep series. This part shifts to moving technology across borders and to the patchwork of privacy law. In this session, we'll cover export controls and the major privacy laws you must recognise. We'll answer several questions. Why does the government control the export of technology? How are encryption products treated? Where does the right to privacy come from? What limits how the government handles your data? And which sector-specific privacy laws matter most? Why does this matter beyond the exam? Because a single deployment can trip several of these rules at once. Picture a team pushing an encryption feature to users in another country while storing health records in the cloud. That one release touches export law, privacy law, and breach rules together. Knowing the map keeps you from an expensive misstep. Why does the government control the export of technology? Because the same tools that power commerce can power a military. Strong computers and encryption are dual use, valuable to allies and dangerous in the wrong hands. So 2 regulation sets govern what leaves the country. One controls true military and defence items and the technical data behind them. The other covers commercial goods that could have military uses, including an entire category for information security products. There is also a short list of countries of concern where extra restrictions apply. Think of it as a customs gate that inspects not just goods, but capabilities. How are encryption products treated? With special care, because encryption once counted as a near weapon. Under older rules, exporting even modest encryption abroad was almost impossible, which put domestic software makers at a real disadvantage. After heavy lobbying, the rules were relaxed to help the industry compete. Now, retail and mass-market security software can be submitted for a review that is supposed to finish quickly, after which firms may export freely. Picture a fast-track lane at that same customs gate, opened once officials confirm the product is common commercial strength. Where does the right to privacy come from? Not from any single line in the founding document, which is what makes it contested. The anchor is the constitutional protection against unreasonable searches and seizures. Courts have stretched that idea over time to cover wiretapping and other intrusions. So privacy in the United States is less a single wall and more a patchwork stitched from court rulings and targeted statutes. Think of it as a quilt. No one law covers everything, so many narrow ones cover specific corners. What limits how the government handles your data? A foundational Privacy Act restricts what federal agencies may keep about citizens. Agencies must hold only the records they truly need, let people view and correct their own records, and get consent before sharing them, with narrow exceptions. A separate Communications Privacy Act makes it a crime to intercept electronic messages like email and voicemail, and a later amendment forced carriers to enable lawful wiretaps with a court order. Anti-terrorism law broadened surveillance powers, some of which lapsed and were restored under a successor act. And a Cross-Border Data Act lets authorities compel companies to hand over data even when it sits on servers abroad. Picture a set of guardrails on government reach, each one added after a new technology outran the old rules. Which sector-specific privacy laws matter most? The ones tied to health, finance, children, and education. Health law imposes strict privacy and security duties on providers and insurers, and a later update extended those duties to the business partners who handle protected health information and added breach notification. Financial law loosened barriers between banks and insurers but required written privacy notices to customers. Children's online privacy law demands verifiable parental consent before collecting data from young children. Education privacy law grants students and parents rights over school records at any institution taking federal funding. And identity theft law finally treats the victim, not just the defrauded creditor, as the injured party. Think of these as targeted patches, each sealing the gap in one high-risk industry. How do organisations learn a breach happened? Through notification laws, which mostly live at the state level. One pioneering state law was the first to require telling individuals when their personally identifiable information was exposed, covering things like a name paired with a financial account or government identifier. Other states copied that model until the whole country was covered. At the federal level, only the health sector carries a nationwide breach notification duty. Picture a smoke alarm requirement. Most of the rules about when it must sound were written state by state, not from one central switch. So let's bring it together. Export controls exist because computers and encryption are dual use. So two regimes police what leaves the country, with a fast lane for common security software. Privacy rights are a patchwork anchored in the search and seizure protection and stitched together by targeted statutes. Federal privacy and surveillance laws set guardrails on government reach, including across borders. Sector laws patch the high-risk industries of health, finance, children, and education. And breach notification lives mostly at the state level, with health as the one federal exception. Learn the map, and each release you ship stays on the right side of it. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to Section 4.2, Part 4. This is the 30-second session of the CISSP Exam Prep series. This part rounds out our legal tour with workplace privacy and the international rules. In this session, we'll cover privacy at work and the major privacy regimes beyond the United States. We'll answer several questions. When can an employer monitor its people? What makes the European approach different? What core rules does its flagship regulation set? How does data move across borders under that regime? How is artificial intelligence being regulated? And how do other nations protect personal data? Why does this matter beyond the exam? Because your users and your data rarely stay in one country. Picture a support team in one region reading messages from customers in another, all stored on shared systems. Whether that monitoring is lawful, and whether that data may even cross the border, depends on rules that differ sharply by nation. Guess wrong, and the fines are steep. When can an employer monitor its people? Whenever there is no reasonable expectation of privacy on company equipment. Courts protect privacy, but only where a person could reasonably expect it. A sealed letter carries that expectation. A postcard does not. On employer-owned systems, courts have found employees generally cannot expect privacy, so routine monitoring is allowed. But the employer must remove any hint of an implied expectation first, through policies, contract clauses, and login banners. Think of a warning sign posted at the door. Once everyone is clearly told the space is watched, the expectation of privacy disappears. What makes the European approach different? Its breadth. Where the United States stitches together narrow, industry-specific laws, the European model is comprehensive and applies to almost all identifiable personal information. It does not wait for a particular sector to be at risk. Instead, it sets one broad standard for handling personal data across the board. Picture the difference between many small fences around specific fields versus a single wall around the entire property. The European instinct is the wall. What core rules does its flagship regulation set? A handful of principles that govern every use of personal data. You must have a lawful basis and be transparent about processing. You limit data to the specific purpose you disclosed, and you collect only what you actually need. You keep it accurate, and you keep it no longer than necessary, honouring a person's right to be forgotten. You secure it, and you take accountability, meaning you must be able to prove your compliance. Crucially, the regulation reaches any organisation that handles data about its residents, even one based elsewhere. Think of these as 7 house rules that follow the data wherever it goes. How does data move across borders under that regime? Only through approved channels, because sending personal data out of the region is tightly controlled. A company can adopt standard contractual clauses, which are pre-approved terms it drops into its contracts, or it can build binding corporate rules, an internal rulebook for transfers between its own units, though that path is slow and mostly used by very large firms. An older safe harbour arrangement between the two regions was struck down by a court, so companies can no longer lean on it. Picture a border crossing that only opens for travellers carrying one of a few specific pre-stamped passports. How is artificial intelligence being regulated? Through a risk-tiered framework that sorts systems by how much harm they could do. The most dangerous uses, like social scoring, are simply banned. High-risk systems, such as those in hiring or critical infrastructure, face strict duties around data quality and human oversight. Limited risk systems, like chatbots, mainly owe transparency, so users know they are talking to a machine. And the vast majority, minimal risk tools like spam filters, carry no extra obligation. Think of a traffic light system for algorithms, where the color depends on the stakes if the system gets it wrong. How do other nations protect personal data? With their own comprehensive laws, most echoing the same core themes. A regional economic group publishes a voluntary privacy framework to ease trusted cross-border flows. Canada's law governs how commercial businesses collect and use personal information, with some provinces running their own equivalent rules. China's law demands explicit consent, limits collection to what is necessary, and tightly restricts sending data out of the country. South Africa's law sets multiple conditions for lawful processing, with special care for sensitive data and children. The pattern is unmistakable. Around the world, the same principles keep reappearing under different names. Think of many countries independently arriving at the same short list of fair data rules. So let's bring it together. Employers may monitor company equipment once they remove any reasonable expectation of privacy. The European approach is comprehensive rather than sector by sector, and its flagship regulation sets a handful of binding principles that follow the data anywhere. Cross-border transfers out of that region require pre-approved channels, and artificial intelligence is governed by a risk-tiered framework. Other nations, from Canada to China to South Africa, echo the same core privacy themes. Learn the shared pattern, and you can reason about a law you have never seen before. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to section 4.3. This is the 33rd session of the CISSP Exam Prep series. In this session, we'll look at how individual states shape privacy law. We'll answer several questions. Why do states matter alongside federal and international rules? What rights does the landmark state privacy law grant? And where is this trend heading? Why does this matter beyond the exam? Because your organisation is bound by the laws of every place it does business, not just its home base. Picture a subscription service with customers spread across many states. A single new state law can force a change to how the whole product handles personal data. Missing that change is how compliance gaps quietly open. Why do states matter alongside federal and international rules? Because states often move first. When a national privacy law is slow to arrive, individual states step in and write their own. Those state rules can then ripple outward, becoming the template that other states copy and that federal lawmakers eventually study. We saw the same dynamic with breach notification, where one state set the pattern, the rest followed. Think of states as laboratories. A rule tested in one can spread across the whole country. What rights does the landmark state privacy law grant? A sweeping set of consumer protections, modelled closely on the comprehensive European approach. Consumers gain the right to know what information a business collects about them and how it is used and shared. They gain a right to be forgotten, letting them ask that their personal data be deleted in certain cases. They can opt out of having their personal information sold. And they are protected from discrimination or retaliation for exercising any of these rights. Picture handing each customer a control panel for their own data, with switches to see it, delete it, and stop its sale. Where is this trend heading? Toward more of the same in more places. The pioneering state did not stop at one law. It extended and strengthened its original rules, and other states have passed comparable privacy laws of their own. The result is a growing patchwork that any national business must track state by state. Think of a wave that starts on one coast and keeps rolling inland, each state adding its own version as it arrives. So let's bring it together. States matter because they often lead, testing privacy rules that later spread nationwide. The landmark state law gave consumers real control, the rights to know, to delete, to opt out, and to be free from retaliation. And the trend is expanding, with the original state strengthening its rules and others following. Track the states where you operate, and you stay ahead of the patchwork rather than behind it. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to section 4.4. This is the 34th session of the CISSP Exam Prep series. In this session, we'll turn all those laws into a working compliance practice. We'll answer several questions. Why has the compliance landscape grown so tangled? Can a requirement bind you without being a law? What new pressure does artificial intelligence add? Who actually keeps an organisation compliant? And how is compliance proven and reported? Why does this matter beyond the exam? Because compliance is where the abstract law meets your actual controls. Picture a retailer that accepts card payments, files financial reports, and rolls out an automated hiring tool. 3 very different rulebooks land on the same security team at once. Someone has to track them all, prove they are met, and report the results. That someone is often you. Why has the compliance landscape grown so tangled? Because obligations now pile up from many directions at once. An organisation can face laws, agency regulations, and contractual commitments all at the same time, and those requirements often overlap or even conflict. Untangling them takes deliberate planning, not guesswork. You have to know which rules apply, where they clash, and how to satisfy them without tripping over one another. Think of standing at the intersection of several rulebooks, each written by a different author, none of them talking to the others. Can a requirement bind you without being a law? Absolutely. And the classic example is the payment card, industry data security standard. No legislature passed it. Instead, it binds you through a contract. The merchant agreement between a business that takes cards and the bank that processes the payments. Its aim is to protect cardholder data across a set of core requirements. Things like securing networks, protecting stored account data, encrypting data in transit, restricting access by need to know, and testing security regularly. And it reaches beyond merchants to any service provider that stores or handles card data on their behalf. Picture a private club's rulebook. You never voted on it, but the moment you sign the membership, you are bound. What new pressure does artificial intelligence add? A fresh layer of compliance built around fairness and transparency. As organisations rush to adopt automated decision-making, new frameworks demand that these systems be explainable and free of hidden bias. If a model produces unfair or discriminatory outcomes, the organisation can run afoul of anti-discrimination rules. So the obligation is not just to keep data safe, but to keep the algorithm's decisions defensible. Think of an automated loan reviewer. If it quietly disfavours a group, that is now a compliance problem, not merely a technical bug. Who actually keeps an organisation compliant? Dedicated compliance specialists, because the work never stops. Many organisations employ full-time staff whose whole job is tracking the shifting regulatory environment. They monitor controls to confirm ongoing compliance. They coordinate audits, and they handle the reporting obligations the organisation owes. This is not a set-and-forget task. Rules change, the business changes, and the two keep colliding. Picture a lookout who watches both the horizon and the deck, spotting new rules and new risks before they become violations. How is compliance actually proven? Through audits performed by several different parties. Your own internal and external auditors may review controls, or a regulator and its agents may come in directly. As an example, financial auditors might test the information security controls behind financial systems to satisfy corporate accountability law. Some standards go further and require that you bring in approved independent auditors who report their findings straight to the regulator. Think of it as an inspection. Sometimes you check yourself, sometimes an outside inspector arrives, and sometimes the rules dictate exactly who that inspector must be. How is compliance reported once it is proven? Through regular reporting to the people and bodies who need assurance. Beyond formal audits, organizations routinely report their compliance status to internal and external stakeholders. A board of directors, or more often its audit committee, may require periodic updates on obligations and status. And where a business is not required to undergo a full third-party audit, a standard may instead ask it to complete and submit a self-assessment of its compliance. Picture a status dashboard passed up the chain, so leadership always knows where the organization stands. So let's bring it together. The compliance landscape is tangled because laws, regulations, and contracts stack up and overlap. A requirement can bind you by contract alone, as the card data standard does through a merchant agreement. Artificial intelligence adds a new duty to keep automated decisions fair and explainable. Dedicated specialists track it all, audits by various parties prove it, and regular reporting and self-assessments communicated upward. Master this rhythm, and compliance becomes a steady discipline rather than a fire drill. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session. Welcome to section 4.5. This is the 35th session of the CISSP Exam Prep series. In this session, we'll build security into how you choose and manage vendors. We'll answer several questions. Why does vendor security deserve its own review? When in the relationship should you review a vendor? What questions reveal how a vendor protects your data? What deeper risks hide behind a vendor? And how do you right-size the review? Why does this matter beyond the exam? Because your data now lives on machines you do not own. Picture handing your customer records to a cloud analytics provider you have never audited. Their weakest control is now your exposure, and their breach becomes your headline. Vendor security is not the vendor's problem alone. It is squarely yours. Why does vendor security deserve its own review? Because outsourcing the work does not outsource the risk. As organizations lean on cloud services and outside vendors to store, process, and move sensitive information, those vendors inherit access to your data. If you never inspect how they protect it, you are simply trusting on faith. So security professionals fold formal reviews into the contracting and procurement process itself. Think of hiring a contractor to hold your spare keys. You would want to know how they store them before you hand any over. When in the relationship, should you review a vendor? At 2 points, not just one. The first is during initial selection, when you evaluate a vendor's controls before you sign anything. The second is ongoing, through regular vendor governance reviews across the life of the relationship. A vendor that was solid at signing can drift over time, changing its systems, its staff, or its own subcontractors. So the review is a recurring checkpoint, not a one-time gate. Picture a health inspection for a restaurant. Passing once does not exempt you from every inspection that follows. What questions reveal how a vendor protects your data? A focus set that probes their controls directly. What kinds of sensitive information will they store, process, or transmit? What controls guard that information, and how is your data kept separate from other clients' data? If encryption is the safeguard, which algorithms and key lengths do they use? And how do they manage the keys? And what security audits do they run? And will they let you see the results? Think of these as the questions you would ask before trusting anyone with your valuables. You want to see the vault, not just be told there is one. What deeper risks hide behind a vendor? The ones that reach past the vendor itself. Does your vendor rely on other third parties? And do your contract security terms extend to those subcontractors too? Where will your data actually live? And if it crosses into another country, what legal implications follow? What is the vendor's incident response process? And how quickly will they tell you about a suspected breach? And what protects the ongoing integrity and availability of your data in their hands? Picture a supply chain. The weak link may not be the company you signed with, but the one they quietly signed with. How do you right-size the review? By matching its depth to the actual stakes. There is no single checklist that fits every vendor. You tailor the scope to your organization's specific concerns, the kind of service the vendor provides, and the sensitivity of the information you will share. A vendor handling public marketing copy warrants a lighter touch than one holding regulated customer records. Think of adjusting the locks to the value inside. You do not fit a bank vault door to a garden shed or a flimsy latch to a treasury. So let's bring it together. Vendor security deserves its own review because outsourcing the work never outsources the risk. You review at selection and again through ongoing governance, since a good vendor can drift. Direct questions reveal how they protect and segregate your data, and deeper questions expose subcontractors, data location, breach response, and availability. Then you right-size the review to the stakes. Handle procurement this way, and every vendor you trust has earned it. The MCQs covering all the topics and concepts from this session are available on RooCloud.com. Practice the chapter-specific MCQs before moving on to the next session. Thanks for watching. If you have any questions or feedback, post a comment below or email us. I will see you in the next session.